It is a scene that strikes at the very heart of the Donald Trump mythos. The man who spent decades crafting a public persona as the ultimate self-made tycoon, the billionaire dealmaker who looked down from his gilded tower upon mere mortals, now faces the ultimate humiliation. His lawyers have been forced to go before a New York court and admit a staggering reality. They cannot find anyone willing to lend them the money to pay a debt that, by his own claims, he should be able to cover with relative ease. The narrative of invincibility, carefully cultivated through reality television and countless tabloid headlines, is colliding with the cold, unforgiving arithmetic of a civil judgment. The figure is staggering, even by the standards of the ultra-wealthy. This is not a parking ticket or a minor contractual dispute. We are talking about a demand for $464 million, a sum that represents one of the largest civil judgments against an individual in American history. This amount, comprised of a $355 million penalty for fraud plus interest that accrues daily at a rate of 9%, is the result of Justice Arthur Engoron's landmark ruling. The court found that Trump, along with his sons and their company, engaged in a years-long pattern of deceit, systematically inflating the value of assets like Trump Tower and Mar-a-Lago to secure favorable loans and insurance terms. It is a judgment that directly challenges the foundation of his business empire. As the clock ticks down to a critical deadline, the drama unfolding in New York is not just about money, it is about power, identity, and the potential unraveling of a former president's financial legacy. The stakes could not be higher. If Trump fails to secure a bond, essentially a guarantee to the court that he will pay the full amount if he loses his appeal, the New York Attorney General, Letitia James, is legally empowered to begin seizing his assets. The man who built an empire on the bedrock of New York real estate could see pieces of it taken from him, one property at a time, by the very state that served as his launching pad. To understand the magnitude of this moment, one must look back at the long legal road that led here. For years, New York Attorney General Letitia James, a Democrat who campaigned on a promise to hold Trump accountable, investigated his business practices. The probe, launched in 2019 following explosive testimony from Trump's former fixer Michael Cohen, painted a picture of systemic deception. The lawsuit she eventually filed in 2022 was not a simple case of exaggerating a bit of wealth. It alleged a massive coordinated fraud that involved overvaluing assets by billions of dollars. At its core was the accusation that Trump's annual statements of financial condition were not just public relations puffery, but fraudulent documents used to deceive banks and insurers. The trial itself was a spectacle, a 2.5-month legal war that saw the former president take the stand in his own defense. Inside the Manhattan courtroom, Trump bristled under oath, attacking the judge as extremely hostile and the attorney general as a political hack. His defense was consistent with his public persona. There were no victims, the banks did their own research and were happy with his business, and the whole affair was a politically motivated witch hunt. But the evidence presented by the state told a different story, detailing specific instances of fraud, including the infamous claim that his Trump Tower penthouse was nearly 3 times its actual size. In his scathing 92-page decision, Justice Engoron did not mince words. He wrote that the frauds found leap off the page and shock the conscience. He dismissed the defense's expert witnesses as those who simply denied reality. While he stopped short of issuing the corporate death penalty that would have dissolved Trump's companies, the punishment was still severe. Beyond the financial penalty, the judge imposed a 3-year ban on Trump serving as an officer or director of any New York corporation and barred him from obtaining loans from New York state banks for the same period. It was a direct assault on his ability to do business in the city that made him famous. The immediate crisis, however, is the cash. Trump's legal team has filed an appeal, but under New York law, to pause the enforcement of the judgment while that appeal plays out, he must post a bond for the full amount. This is where the narrative of immense wealth meets the practicalities of high finance. In a stunning court filing, Trump's lawyers revealed that they have approached more than 30 surety companies, the firms that underwrite such bonds, and every single one has turned them down. The reason is as telling as the rejection itself. These companies refuse to accept real estate as collateral. They want cash, stocks, or other liquid assets. This demand for liquidity exposes a potential vulnerability in the Trump Organization's finances. To secure a $464 million bond, an underwriter would typically require collateral worth far more than the bond itself. Trump's lawyers have stated that the bonding companies would demand 120% of the judgment in cash or cash equivalents, a staggering $557 million. While Trump claims to have nearly $500 million in cash, his lawyers argue that tying up that much liquid capital would cripple his business operations, potentially violating loan covenants on his properties that require a minimum level of liquidity. The situation has created a surreal paradox. On his Truth Social platform, Trump has declared, "Through hard work, talent, and luck, I currently have almost $500 million in cash." Yet simultaneously, his lawyers are in court arguing that it is impossible for him to access enough liquid funds to secure the bond. This contradiction has not gone unnoticed by legal experts and observers. If he has the cash, why can't he simply use it? The answer, his team suggests, is a matter of business pragmatism. He wants to use that money for his presidential campaign, but the optics are undeniably damaging to the self-made tycoon brand. Meanwhile, New York Attorney General Letitia James is preparing for the worst-case scenario for Trump. She has signaled clearly that if the former president cannot pay, she is ready to act. If he does not have funds to pay the judgment, then we will seek judgment enforcement mechanisms in court, and we will ask the judge to seize his assets, she has stated. This is not an empty threat. Her office has already begun the legal groundwork, and as of March 25, barring court intervention, she will be legally free to start the process of liquidation. So, what would that actually look like? The list of potential targets is a who's who of Trump's most iconic holdings. Legal experts and financial analysts point to prime Manhattan real estate, 40 Wall Street, the towering skyscraper in the financial district, Trump Tower on Fifth Avenue, the spiritual home of his brand. Further afield, his Seven Springs estate in Westchester County and even his marquee golf courses could be vulnerable. The process would not be a dramatic televised takeover, but a legal proceeding that could ultimately lead to sheriff sales and public auctions, a spectacle that would be both a media circus and a devastating personal blow. To add another layer of complexity to his financial picture, Trump is simultaneously facing a potential windfall from a completely different source. A merger has been approved that will take his social media company, Trump Media and Technology Group, parent of Truth Social, public. Based on current stock prices, his stake in the newly public company could be worth over $3 billion on paper. However, this is far from a simple solution to his cash crisis. Lock-up provisions, common in such deals, would likely prevent him from selling his shares for at least 6 months, and possibly longer, making this vast paper wealth inaccessible for his immediate legal needs. The political implications of this financial saga are impossible to overstate. As he campaigns to return to the White House, Trump is weaving these legal battles into his narrative of persecution. He frames the $464 million judgment not as a penalty for fraud, but as election interference and a weaponization against a political opponent. This message resonates powerfully with his base, who see the lawsuits as evidence of a deep state determined to stop him at any cost. For them, his defiance in the face of these legal challenges is a feature, not a bug, reinforcing his image as a fighter. But the financial reality could prove to be a more potent adversary than any political opponent. Analysts point out that even if Trump manages to stave off immediate seizure by securing a bond, the interest on the judgment continues to accumulate at a rate of over $110,000 per day. The longer the appeals process drags on, the larger the ultimate bill becomes. If he loses the appeal, he will owe the full amount plus that crippling interest. This creates a scenario where his net worth, even with the Truth Social windfall, could be significantly and permanently diminished. Insiders and legal experts who have followed Trump's career for decades see this as a potential inflection point. Unlike his previous business failures, the casino bankruptcies in Atlantic City, the demise of Trump Airlines, this judgment is a direct personal imposition by the state. It is not a market-driven failure that can be spun as a savvy business move. It is a court of law declaring that he engaged in persistent and intentional fraud. This cuts to the core of the identity he has built for half a century. The image of the infallible billionaire is now legally and financially tarnished in a way that no tabloid story ever could. The global impact is also being felt. For international investors and business partners who have long viewed the Trump name as synonymous with American luxury and success, the judgment sends a chilling signal. The ban on obtaining loans from New York banks effectively cuts the Trump Organization off from the world's financial capital. To continue his ambitious expansion plans, or even to refinance existing debts, Trump may increasingly have to look overseas for capital, turning to lenders in the Middle East or Asia, who may be less risk-averse but also demand higher returns. The coming days will determine the immediate fate of Trump's business empire. He has made a last-ditch appeal to the state's Intermediate Appeals Court, asking them to waive the requirement for a full bond, arguing that his real estate holdings are more than sufficient security. The Attorney General's office has fiercely opposed this, arguing in legal filings that there is nothing unusual about requiring a full bond, even for judgments this large. The appeals court's decision, expected imminently, is the single most critical factor in whether the clock starts ticking on asset seizures. If the court rules against him and he cannot post the bond, the scenario shifts from theoretical to terrifying for the Trump camp. Attorney General James would then be free to go to court to obtain writs of attachment against specific properties. This would involve a painstaking legal process to value the assets and determine what can be sold to satisfy the debt. It would be a months-long, highly public battle, with Trump's lawyers fighting every step of the way to protect his most prized possessions from the auction block. Another potential, though drastic, outcome is bankruptcy. Filing for bankruptcy for the Trump Organization would immediately halt all civil proceedings, including the seizure of assets, through an automatic stay. However, such a move would be politically catastrophic for a candidate running on a platform of strength and business acumen. It would be an admission of defeat that even his most ardent supporters might find hard to spin. Moreover, a bankruptcy judge would then have immense power over his finances, a loss of control that the famously hands-on executive would find intolerable. The appeals process itself is a labyrinth. Even if he posts the bond, the legal fight is far from over. His appeal will go before the Appellate Division, a mid-level appeals court, where his lawyers will argue that Justice Engoron was biased and misinterpreted the law. If he loses there, he can appeal to New York's highest court, the Court of Appeals. This process could take a year or more, keeping the financial sword of Damocles hanging over his head throughout the general election campaign. The case, born in a New York state court, could conceivably wind its way through the system for years. The human element of this drama is often overlooked in the discussion of high finance and legal strategy. For the employees of the Trump Organization, the uncertainty is palpable. The company they work for is facing a leadership crisis, with its top executives, Trump himself and his two eldest sons, barred from running it in New York for years. The independent monitor installed by the court now has significant oversight. This level of scrutiny and instability can demoralize a workforce and make it difficult to retain top talent, further weakening the organization from within. In a twist that underscores the politically charged atmosphere, the fallout has extended beyond the courtroom. Reports have emerged that the Justice Department, under the current administration, has launched an investigation into Letitia James herself, examining whether her prosecution of Trump constituted a form of civil rights violation. James's office has dismissed this as part of a political retribution campaign, but it highlights how the legal system has become a battlefield where the lines between justice and politics are increasingly blurred. Looking at the future scenarios, one possibility is a negotiated settlement. While the rhetoric from both sides is fiercely hostile, it is not uncommon for massive civil judgments to end in a structured payment plan or a deal to hand over specific assets in lieu of cash. Trump could, in theory, offer to surrender a property like 40 Wall Street to satisfy the debt. Whether James would accept such a deal, and whether Trump could bring himself to part with a signature asset, is a matter of intense speculation. Such a compromise would allow both sides to claim a partial victory. Another scenario involves the Truth Social stock. If the lockup restrictions are somehow lifted or expire, Trump could theoretically sell a portion of his shares to raise the necessary cash. However, flooding the market with hundreds of millions of dollars of a single stock could crater its price, reducing the value of his remaining stake and angering other investors. It is a high-risk financial maneuver that could create more problems than it solves, turning a paper fortune into a liquid one at a potentially devastating cost. As we look toward the closing arguments in this long-running saga, one thing is clear: the outcome will define the post-presidency of Donald Trump in ways that history has yet to fully comprehend. He has spent his entire life building an empire and a persona based on the idea of success, of winning. This judgment, and the struggle to meet it, represents the most significant institutional challenge to that persona. It is a test not just of his wealth, but of his resilience and his ability to adapt to a world where the rules can no longer be bent to his will. The clock is ticking toward a deadline that could reshape the American political and financial landscape, whether through a dramatic last-minute bond, a humiliating asset seizure, or a protracted and bitter appeal. The resolution of this case will be a defining moment. For the man at the center of it all, The man who once boasted that he alone could fix the system is now demanding its pound of flesh. And for the first time in a long career of defying expectations, the price of admission may simply be too high.